Hello, this is Dr. Colbert. I am going to do a little informal review of the book that we read in class, Executed on a Technicality. And I just wanted to, a little bit about the author that you read. He was pro-death penalty, then switched his mind once he saw all of the injustices and inequities, and now he's actually against the death penalty. I think that's really important when you think about most people in our society today, especially in Oklahoma, they're pro-death penalty. They think, back to, again, retribution, which is the oldest form of punishment, eye for an eye, that if you kill, then you too should be killed. We hear on the news all the time how the crime was just so heinous, and the Boston Marathon bomber, you think 9/11, right? We just had the marathon run. People like that, yes, they should be killed. It makes sense on a micro level, but back to a macro level, when you think about the cost of the average execution is about $2.3 million compared to just spending life without the possibility of parole. In jail is less than $1 million, closer to about $800,000. So it doesn't make sense there. States that have lower crime rates, which are up north, actually don't have the death penalty. States that have the highest crime rate, when you look at Texas, California, Louisiana, down south, we actually have higher rates of execution. So you can't say that execution serves as a deterrent either. So I think it's important that people who are really for the death penalty, that we kind of not necessarily pick it apart, but think about, well, what are your main arguments? If it's just an eye for an eye, okay, there's no way really to argue against retribution, but it doesn't serve as a deterrent. It's not cost effective. Those kind of arguments, I think we can pick that away. And especially, executing innocent people and all of the inequities in the death penalty, right? Women, we very rarely get the death penalty. It's normally reserved for the poor, minority, indigent. They can't afford good attorneys, things like that. So with regards to the book, a couple of things. He said, he notices that there were a lot of injustices. Again, it's quite common. Kind of in the preface, he mentions 20,000 homicides occurred every year. And in a busy year for executioners, 1/4 of 1% of murderers will be executed. Okay, so think about that, eye for an eye. 1/4 of 1% of actual murderers will be executed. Okay, and they're not people like he says, Charles Manson and things like that. Who knows how that actual DA that's in that county picks and says, hey, I'm going to get you for the death penalty. It's just, there's no real rhyme or reason. It's, okay, do we have enough evidence against you? Do you have a lot of priors? Is there a lot of public opinion and things surrounding this case? Is that DA up for election, right? So he or she has to look like that they're tough on crime. Let's see. What else we have here? In half of all, this is still in the preface, in half of all death penalty cases over a 20-year period, a federal courts reversed either the conviction or the sentence or both. In no other area are reversals the norm. Okay, so in half of all death penalty cases, right, there's some kind of reversal, either the conviction or the sentence. So back to that again, it's just the lawyers, they're inadequate, they're not qualified. Because the death penalty is that bifurcated system, meaning you have a trial and then a sentence phase, you're guilty or not guilty of the crime, and then you come back again and you have another trial to see if you're going to get the death penalty or not. And so you've really got to be trained in death penalty cases to be an effective attorney. And sadly, a lot of attorneys aren't equipped to try these death penalty cases or to help with them, right, and to represent their clients. We know that the death penalty was reinstated in 1976, right, with Gregg versus Georgia. Okay, it was the Furman case, I think, in 1972, where the death penalty, they had first, had taken it off the books. So 4 years later, it was reinstated. Let's see. Right now, death row inmates are less than, 14%? Defense lawyers are still frequently incomprehensibly incompetent, is what the author says. And let's see. Oh, he mentions the case Atkins versus Virginia, where the Supreme Court decided in June of 2002. The court held that the Eighth Amendment to the Constitution said that you can't execute murderers who are mentally retarded, which is kind of nice. Sadly, there's a lot of stories out there too where they're going to execute someone and the guy, he served his last meal. You guys watched a video last week about the last 24 hours and you get your last meal. They'll take a guy his last meal and he'll say, oh, I don't want my dessert now. I'm going to save it for tomorrow. Not really comprehending the idea that there is no tomorrow. This is it. And having, with the Atkins case of not executing someone that's mentally retarded, that scale is actually at an IQ of below 70, which is really about a second grade mentality or IQ. So if you think about it, even someone that's on that cusp and say they have an IQ of 71 or 72, you're looking at a third grade mentality, right? And so you'd have to ask yourself, really, does a third grader understand that if I kill someone, then I'm also going to be killed, right? I have a second grader and I'm thinking, I don't think next year, right, in a few months when school's over and school starts again, and he's pretty talented and smart. He might have an IQ of 70 now, I'm not sure. But I don't think he understands that if he were to, God forbid, kill someone now, that his life would be taken away forever and that he would face the death penalty. And so we have to think that that bar is really low when it comes to executing someone that's mentally retarded. And sadly, it's we think about, you see this grown man that has murdered someone, and it's hard for us to understand that it's really someone trapped, like a child's brain trapped in an adult's body that's being executed. And so the bar is pretty low there. Also, you have to have been diagnosed with this mental retardation and low IQ early on. You can't come in, say at the age of 25, murder someone and then say, oh, test me, right? I'm mentally retarded. The courts has to show from early on in school that you were in, say, LD classes and that you had a learning disability and that you've kind of suffered from this mild mental retardation. You can't just spring it on someone and think that that's going to fly, right? Because then that would bring up more lawsuits and setbacks that, did they lie on the test or did they cheat on the test or something like that? So there's kind of some ways there to catch that. What else? He talks about in here how it is, in short, easier, if not easy, to execute something that is not even human. And talks about how, again, when someone is you see it all the time on social media, or if there is an execution, you just name the most gruesome detail about their crime that you can to really dehumanize that person, that they're just this despicable animal and that they just need to be put down. And that is, it kind of serves of justification of, sure, let's spend a couple extra $1 million that we could give back to the community or to our police officers or to our teachers or to our counselors to prevent crime, right? Let's go ahead and spend it on the back end and execute people because this person isn't even human. So we tend to do that a lot when someone is up for death row, to really dehumanize them, to make it easier to kill them. What else did we get here? Oh, and then the book, kind of when you get into chapter 1, you start mentioning, like the first chapter is the execution of Carl Johnson. And he says, Johnson was my client when he started representing him. He did not receive a penny for representing him, right? So it was pro bono. He, let's see. Oh, he does mention in here about how the death penalty has these 3 distinct phases that he breaks them up into, right? The first stage being the trial, Then the second stage is that appeal. And then that third stage is that habeas corpus appeal. Okay, which now is becoming more severely limited. People don't have as much access to it now because we're in a phase right now with our criminal justice system where we don't feel sorry for criminals, right? It's kind of this pendulum swings from retribution, eye for an eye, we're really tough on crime, right? To it swings over to kind of being more loose toward rehabilitation. And we're not over here yet. We're still over here really strict. A lot of that is political and who's in office. And so, over the past several years, we've really limited that habeas corpus appeal. Let's see. He mentions... it says, contrary to popular myth, the death row inmate will spend the remainder of his life, in these really kind of squatty positions where, for example, in Texas, they live in a 60 square foot cell. They're there for 23 hours a day. For 1 hour, they're able to come out, but that's for solitary exercise. They are moved from their private cell to a larger cell, kind of a day room. They actually don't have TVs, things like that, like, what people would assume. So it kind of stinks, when you think about the death row, when you look at it even more, that they are really more secluded. People, you don't really want to be on death row because you're not in with the rest of the general population. You're by yourself. You have a cell to yourself. So you don't get a lot of that human interaction. So, for you psych majors, you have to think mentally what that also does for you. The average person spends 15 years on death row. We don't execute people really fast. I think in California, it's 18 years is the average number of years that you're on death row. And so imagine spending that much time just alone by yourself. I know Oklahoma, like in the H unit, which is below ground where they house death row inmates, it's really dark. The lighting is just kind of that faint yellow light, but there's no windows. You can't see anything. But there are, several cells there that are individual cells. And so sometimes the guys can, depending on the guard, can kind of, talk loudly to one another and get to know one another. This is just being at OU, having, we had some of the guys that were on death row, 2 of them come and talk in our classes. And so they were, being descriptive and telling us, what it looked like down there and, what they could do, what they couldn't do. And it's kind of sad. I remember one guy told us, he said, of all the people down there, he said, I could figure out, he said, people's stories and how they talked and things like that. And he said, I could tell the ones that were guilty. And he said, and I wasn't the only one that wasn't guilty. And he gave us a couple of names and he said, I feel in my heart by the way that these people talked, I know that they're innocent too, and that there are other innocent people that are going to get executed and that are in prison that shouldn't be there. And so that's just kind of sad to think about. He talks about, the socioeconomic status, that it does matter. He touches on the O.J. Simpson case, right? And being able to afford the, quote, dream team, which is what they called O.J.'s 5 attorneys that represented him in his trial. That most of us, I would say in society, we couldn't afford, right? If we were up for the death penalty. It says, for example, criminal defendants in Texas who can afford to retain private counsel are 3 times more likely to be acquitted than are indigent defendants who rely on court-appointed attorneys. He's talking about one. Upon investigation, it turned out that he was, in fact, present. It just that he was asleep. Oh, that was Carl Johnson. Still, his case, I guess why. Maybe he took over. I can remember... there's lots of stories when you look at being incompetent online and these attorneys where they'll show up to court drunk. One I remember, I don't remember if it was in Texas, but he actually was drunk and he urinated on himself, falling asleep. Again, just really being incompetent when you think about, sadly, the indigent what they can afford and who they can afford to represent them. And so you just try to find some, fly-by-night attorney who says, yeah, I can do it, and, you're hoping your family's all scrounging for all the money that they can get, and all the paychecks and things like that they can pawn off and sell, to get you some kind of legal representation, hoping, hey, it's not a private attorney. I need, this representation. And then you spend all your money on this representation. And you're found guilty anyway. And once you're found guilty, it's really hard. It's an uphill battle now to try to prove your innocence or why you should get an appeal and a new trial. Okay. Again, it's saying here during the second phase of the trial, the goal of the defense lawyer is to persuade the jury to spare his or her client's life. And so that's what I was saying with that kind of that second phase that you have. The person's found guilty of a capital crime. So, should they give that person death or should they give him life? And that's when you're going to introduce these, what you call mitigating or moderating factors. Mitigating factors. Did the person have prior convictions, or are they a convicted felon? Or are they an upstanding citizen, right? And they have children and they belong to the church and things like that. So you're going to have, the judge is going to introduce all these things. They're probably going to have some character witnesses there, things like that. Let's see. It says here that the court denied Carl's appeal by a vote of 7-2. Justices Stevens and Ginsburg voted to grant the stay. So it looks like his case actually went all the way to the Supreme Court. What else? We do know that federal judges, I mentioned on page 21, federal judges are appointed for life. Okay. And so when you think about appointing, just like Supreme Court judges, right, being appointed by the president. And so back to when you think about being political, right, and the way that our laws are formed depends on if there's an opening. I think Obama had appointed a Supreme Court judge. Now we know that Trump has appointed a Supreme Court judge. Ginsburg is getting older. And so at some point, probably within the next 10 years, someone is going to be appointing a new one. So depending on who appoints them, right, depending on if they're dependent or Democrat or Republic, also depends on our Supreme Court and if they're going to be lenient, if they're going to be more strict, and how they're going to rule in some of these cases. On page 23, it talks about Calvin Burdine was a former Texas death row inmate who represented by the same lawyer who represented Johnson, and that lawyer slept during Burdine's trial. Okay. So again, I mean, these are in the court records that this is happening, and just because you have an attorney that sleeps, it's not an automatic appeal that you get a new trial and you get a new attorney, right? Some people would say, and depending on that appellate judge, right, they could actually say, you know what, it doesn't matter. There was enough facts there that even if he or she wasn't sleeping, you would still be found guilty. So, the appeal is denied, which is probably sounds crazy to you or I because that's just negligent, right? I mean, that's not even legal representation, which you should get and what you're supposed to get in the court of law if your attorney is sleeping. But for some, that's not enough to get an appeal in a new case. When this book was written, it says more than 140 men have been released from prison on the basis of DNA evidence. And of those, more than 20% actually signed confessions. Okay, that's another issue too. If you looked at that deathpenaltyinfo.org, and hopefully you write about it in your paper, I think there's been over 200 now exonerations based on DNA evidence. The DA does not have to test the DNA if it's there. A lot of times DNA can just sit for 15, 20 years and then it's destroyed or it's never tested. And they don't have to. And that's something that we need to think about when we're electing the district attorney, which is a publicly elected official, that it should be mandatory. We can ask them, where do you stand on this? Do you think that it's mandatory that if there's DNA in a murder case or something like that, that it be tested, right, to help get at the actual truth? And then these signed confessions, right? You get people in there that would, police officers that continue to hound you and then say, you know what, if you just confess, right, then we'll go to the DA and we'll say that, you know what, this person is remorseful and we'll just try to get you a lighter sentence, something like that. And so if you don't confess, you're looking at life or you're looking at the death, the death penalty. So your best bet to save your own life is to confess to this, right? And so you can kind of get that coercion. Sadly, that almost a fourth of these people actually signed confessions and they didn't actually do it. Okay. Your book talks about Fierro signed a confession that he and Oleg had robbed Castanian. This is on page 28. Oh, and they talk about the evidence, things like that. So giving you an example of why someone would actually confess. In 31, it says that the state court trial judge believed that Fierro had given his confession freely. And then no, Fierro said he insisted the confession was extracted from him by threats to harm his parents. Wow. So, let's see. One rule is the Fifth Amendment to the Constitution, which, among other things, prohibits the police from coercing a confession. That's on page 34. Used to, confessions, they did not have to be recorded. Now they actually have to be recorded. But things can mess up during recordings. Things can be erased or altered. And who's to say how much coercion happened? So, for example, some of these testimonies, sometimes when you're into the police or these interrogations can last 13, 14 hours. And so mentally think back to just your psyche. If you are, being hounded and pounded by these police officers for 13 hours, not being able to get anything to drink or anything to eat, over and over, you're just at some point, you just mentally collapse. And it's like, okay, fine. What do I need to do to get out of here? Right. And yes, okay, it happened like that. And it's kind of sad because you see, you can go on Google and kind of some of these cases, you can look up coerced, testimonies and things like that, interrogations. And it's just kind of sad, especially of juveniles, right? Who the parents say, yeah, you can talk to them, not a big deal. But then they're in there for, 10, 12 hours. And, mentally it just breaks a kid. Let's see. What else we have here? Let's see. Let's see. On page 45, I had highlighted, it talks about the Texas Court of Criminal Appeals by a vote of 5-4. So again, a close ruling ruled that Fierro had not provided that the coerced confession had caused him any harm. The state of Texas set an execution date. Okay. So it looks like Fierro lost. Statute of limitations was starting to run. So back to what I was saying with regards to the habeas corpus, you only have a few years to hurry up and fight that. And then basically your statute of limitations or the time runs out. Okay. Years later, Fierro was still in prison. He began to develop illusions. He started returning my letters unopened. He didn't want to see him. Basically, he was going insane, being in prison. Okay. He didn't recall who he was. He lost a lot of weight. It said he, lost, close to 100 pounds. The guards taunted him, laughed at him. Yet, if Fierro dies in prison, it will not be Texas provided that he killed Nicholas Canaton. It will be because Fierro did not convince the state court that he did not, and because no federal court will even let him try. If Fierro is executed, it will be because a technicality allowed the authorities to coerce a confession from him and then get away with it. Okay? Kind of sad. He does talk about the author Dow in, chapter 3, that the death penalty must be reserved for narrower categories of killings. Okay? So when you think about these cases where there's not coerced confession, there's not DNA that's been sloppy or mishandled or lost, things like that are tainted. But the death penalty, give me 1 second.